Good morning all. Welcome to the second day of national seminar on emerging trends in digital technologies for teaching and learning for the higher education MOOCs perspective. Today's first session we will start with Professor G.V. Reddy sir on IPRs, that is intellectual property rights. Before welcoming sir onto the dais for the session, let us know about sir. Lawyer turned academician, columnist and administrator. Teaching law since 1991. Specialized in constitutional law and IPRs. Holds doctorate on Supreme Court and judicial activism from Osmania University in 1999. Triple gold medalist in LLB and university topper. Gold medalist in LLM, first UTC JRF awardee in law from OU in 1993. Practiced law for 7 years before joining academics. Authored 23 books and published 74 articles on law. Guided 13 PhD scholars and more than 300 LLM dissertations. Visiting faculty at several institutions of repute. On the academic and governing bodies of many institutions, including central universities and national law schools. Possesses rich experience as principal, chairperson BOS, head of department and dean faculty of law, and also as the director of university legal cell and also university foreign relations office. He is currently the director of Professor G. Ram Reddy Center for Distance Education of Osmania University. Sir, please welcome onto the dais for the session, sir.
A very good morning to all the dignitaries who are present here. Dr. Professor Runali ma'am, Director EMRC, Professor Jagdish Rao, my other colleagues from EMRC, the distinguished invitees, research scholars and friends. I have had the privilege of offering a few MOOCs programs during the last about 5 years through Consortium of Educational Communication, and not from the Osmania University, but incidentally from EFLU. My 7th MOOC program is now on air. And one of the important issues today regarding the digital learning or higher education is to ensure that no intellectual property rights are violated while producing the content, including the digital content. And to the best of my knowledge, I have not come across any complaint lodged by anyone regarding plagiarism or copyright infringement with regard to the 4 quadrants which form part of a video lesson. Nonetheless, there is every possibility of some stakeholder claiming that a large portion, a substantial portion of the content has been copied from his own creation, which is copyrighted by him. There may be similar other issues also. Be that as it may, today we shall try to understand the need to protect intellectual property rights in general and IPRs, especially in digital technologies, digital communications, or the e-content, so on and so forth. I need not overemphasize the importance of intellectual property in modern times. We say we are living in the century of knowledge revolution. Everything is related to knowledge. We talk about knowledge economy, we talk about knowledge industries, we talk about the knowledge era. And in this age, intellectual property assumes greater significance. The professors and scholars, you are quite aware of the importance of ensuring that there is no plagiarism, not only in the communication, but also in the research content. Look at the 2018 regulations of UGC regarding the academic honesty and integrity. The same is equally applicable to any programs, any MOOCs, any Swayam programs offered through any national coordinator. And it is the bounden duty of everyone to see that there is no violation of IPRs. This is one important issue. But at the same time, gone are the days of sticking to only the, in fact, the traditional literature which is shared with the participants, the students and others. Today we are talking about the digital content, and it has become quite easy. We can prepare a video lesson, the script of the video lesson within no time if we have some knowledge relating to that subject. The content is so much, the sources are so many, but the real problem is for the course coordinator, for the teaching assistant and for the producer to ensure that the content is original. And it is said that as far as the research or any academic writing is concerned, it consists of only three things. One is the quotations, the second one is paraphrasing, the third one is the summary. Maybe the least content may be the original contribution of the author, which is a fact. And what can be done by the stakeholders is to see that while paraphrasing also, using a different, in fact, phraseology and all, we can be easily found out by our good friend Turnitin or Urkund or many more such softwares. It's not a big deal nowadays. Any amount of paraphrasing, any amount of shortcut methods may not help us in escaping from the glare of these, technological measures. Therefore, let us see first what exactly are intellectual property rights. Then we shall try to discuss a few important issues relating to copyright after 2012. 2012 assumes importance because our Copyright Act of 1957 was drastically changed after, in fact, in the year 2012 with effect from 2014. Today the meaning of copyright is expanded, exceptions have been broadened, and there are a few challenges. People talk about, in fact, the Rameshwari photocopying works case. Recently you must have seen, sometime in 2016, from Delhi School of Economics. There was a very big case, in fact, which changed the dimension of academic publishing or academic use or instructional use. Course facts which were prepared and shared with the students. In the context of course facts, the Delhi High Court held that they do not violate copyright even though substantial portions are taken from different publishers, different authors. Oxford University itself was one of the petitioners or plaintiffs before the Delhi High Court. And recently we have seen some kind of, in fact, open source articles which are downloaded by using technology. What is that called? Sci-Hub. Now the matter is pending before the Delhi High Court. So there are many sympathizers for Sci-Hub because they think that the knowledge must be free. The technical issues are very strong. We don't know what is going to happen, but in America, the lady who is responsible for Sci-Hub has been held responsible for violation of copyright also. With these few observations, let's go for a quick presentation, then let us see what can be done. Well, with regard to the intellectual property rights, there are a number of issues which can be, in fact, just a second. Yes, I don't know whether it is visible or not. To me, it is not visible. These are some of the attributes of intellectual property. We are talking about creations of mind, We are talking about a property which is invisible or intangible. We are talking about something which is value addition and which is cost intensive, time intensive, and intellectual property is not forever. That's the problem. It has a limited shelf life, in the words of Bill Gates. So whatever we create in the form of intellectual property, whether inventions or the literature or in fact the trademarks, the designs, geographical indications, all of them, they have their own in fact anyway, these are some of the attributes of intellectual property. People always say, is it your grandfather's property? Intellectual property can belong to grandfather also, provided it is something which can be inherited and continued forever. That is only in the context of trademarks and geographical indications if it is registered. Otherwise, copyright has limited shelf life. You are talking about, recently we have seen the translation of autobiography of Miraben, one of the disciples of Mahatma Gandhi, and there was a compulsory license issued. It became controversial because even for enabling a third party to come out with publishing something which is already copyrighted, it must come from private domain to public domain. Lifetime plus 60 years after the death. 20 more years time is left out in the case of Miraben because she died about 40 years back. Now the question is the issue of compulsory license. Compulsory license has to be issued because the copyright is still protected. Otherwise, without compulsory license also, somebody can translate it into Marathi, Telugu, whatever it is. This is another important aspect. Then, with regard to the classification, everyone knows we are more concerned about the literary property, the copyright and neighboring rights, as far as our EMRC or digital content or CEC are concerned. And when we are talking about the copyright, again, what exactly is copyright probably is known to all of you. And we are talking about not the originality of an idea, but originality in expression. Copyright protects original expression of an idea, not the original idea. Idea can never be copyrighted. Suppose a particular topic is given to all of us and we are asked to write one page on that. I am very sure that all of us will come out in our own style, which will be our original style, in respect of which we can claim copyright. Idea may be the same, expression will be different. That's what we are trying to do. When I look at number of MOOCs on human rights, there are at least 3 or 4 MOOCs offered through, in fact CEC. Authors are different, the presenters are different, content is different, but idea is one and same. You can't change the idea of human rights, right? As simple as that. And this is about the limited shelf life. No intellectual property can be kept in the private domain forever. It will come into public domain one day or other. Even in case of trademark and geographical indications also. People might say Scotch whiskey is GI, champagne is GI, or Thanduru, red gram is GI, that is the latest. But they will be in the private domain only if they are registered and renewed every 10 years. But otherwise, all the works of Shakespeare or all the literary works, they have already come into public domain. That's the reason why you have to respect Ranganayakama's copyright and also Vishwanatha Satyanarayana's copyright as far as Ramayana, Vishavruksha and Kalpavruksham are concerned. Idea is same, expression is different. As simple as that. So the third column is important. Let us remember only a limited thing, that copyright is protected normally during the lifetime of the author. Author happens to be the creator, plus 60 years after the death of the author. If there is no author, or if there are so many people to whom the authorship cannot be attributed, it may be only 60 years. As simple as that. Then this is something about the copyright. We are talking about expression of an idea, protecting the expression of an idea, not the idea itself. And There is a natural law theory. One who creates must own it. If you are creating for yourself, you are the author. If you are creating a commissioned work, for example, there are so many friends who may be producing number of, in fact, programs, digitally and otherwise. But as part of the employment with someone else, if somebody is producing a program for Inadu, then Inadu is the author. We are not the authors. They are the owners of copyright. But author may be the person who creates, but author need not be the owner every time. Naturally, he is the first author, the first owner of copyright. Author shall be the first owner of copyright, subject to the contract, terms of the contract. So this is another important aspect. Registration is not compulsory. If you are ready to shell out 600 to 700 rupees, anything can be registered under the copyright law. One can, in fact, visit the registry of copyright. Term I have already mentioned. In the good old days, people used to think about copyright as the concern of only lonely and starving authors. A French, in fact, expert said this: copyright is the concern of lonely and starving authors. Today, copyright is the concern of so many industries. We are talking about the education industry, communication industry, cinema industry, entertainment, music, software, whatnot. So copyright has assumed greater importance in recent times. And anyway, I am not for, in fact, I am not advocating protection of only the economic rights of the authors, but two living examples. Whoever imagined that J.K. Rowling's property or assets, not property but annual income, surpassed that of late Queen Elizabeth II long time back. She used to make 5 pounds per second by way of royalty. So that is the economic value of copyright. Then what can be protected under the copyright? There are so many works. We are not worried about all of them. We are primarily concerned with the literary works because what we deal with are the literary works as part of our MOOCs and other programs. Of course, we can also make use of the other works incidentally. So musical works, cinema, then computer programs, sound recordings. This is a sound recording which is copyrighted. And in fact, what our EMRC can do, what CEC can do is to exercise something called broadcast reproduction right. If you are creating a content now, if you have already telecast for 25 long years, you can repeat telecast. You take the case of the repeat programs which are offered through Swayam and all. And for 25 years, you don't require any specific permission from the content creators or others. This is another important aspect. Then copywriting literary works includes all these. I had an occasion to look at the TOU, the terms of use. As far as the Swayam is concerned, it has issued an elaborate document consisting of the terms of use. And all of them include, the terms of use include all these rights. We are talking about right to reproduce. Someone says copyright includes right to copy. Yes, right to copy, but our own work, not others' work. Right to reproduce one's own work, then you are talking about translation, issuing the copies of the work to the public, communication, then making a cinema, translation of the work, so on and so forth. Then ownership, I already mentioned that author is the first owner. You must have seen whenever you produced a program with 4 credits, 3 credits, 2 credits, one of the first things what the producer does or the director of EMRC does is to get the assignment signed. All of you must have signed. And the reason is that you are creating the work. You are naturally the first owner of the copyright. But you are assigning the same to the CEC, to any other national coordinator. Therefore, Section 17, you need not look at it, but as per Section 17, author shall be the first owner of copyright. Author need not be writer. Author is to be understood as a creator. As simple as that. And author can be of derivative works also. Professor Shiv K. Kumar, I remember a few years back, just before he passed away, he was requested to deliver maybe 400 years of Shakespeare In ASRC, American Studies Research Center, now presently the OU Center for International Studies, then 400 years of Shakespeare. Point is, where is the authorship now? Ownership. There are two things. Shakespeare continues to be the author. You can't take it away. But what about the ownership? What about the copyright? Can it be made use of by anyone? There is no copyright at all. It has already expired. Vishal Bharadwaj, the Hindi film producer, most of his films are based on Shakespearean plays. You must have seen. As simple as that. So these are the other, important aspects. Assignment must be specific. It must be in writing. It must specify the work in which copyright is assigned. For example, right to translate. Today we are talking about Mahatma Gandhi's personal secretary or assistant's biography. Long time back, Nehru's autobiography was sought to be translated into Tamil. It became a leading case, and Nehru directed his secretary to assign the copyright to someone called Tirusar Ganeshan only for limited purpose, to translate it into Tamil and publish. Later on, the English publishers contested, stating that he has already assigned copyright to us. Where is the question of publishing the same in Tamil again? The court said there is assignment of copyright only to publish in English. It doesn't include all the languages. It's not specifically mentioned there. In the assignment deed, that must be clearly mentioned. I had an occasion to look at the assignment agreement of CEC, which is very comprehensive. It covers all the languages. This is one important aspect. But it must be signed, it must be in writing. Then continuing with the same, we must identify the work. Sometimes, we write a book, we assign the copyright to a publisher. Then it comes up for revision. Whether we should be given the chance to revise it or he can assign it to someone else. Generally, the authors retain the right to revise. That may also be mentioned here in the assignment of copyright. Sometimes the time is not mentioned. For how many years? You can say, okay, lifetime of the author plus 60 years. It is understood it is the statutory period. But if the time is not mentioned, for what duration copyright is assigned, it means it's only for 5 years. As simple as that. Sometimes territory is not mentioned. We are living in a globalized world. Our works may be published anywhere in the world. If no territory is mentioned, it denotes that it is only within India. These two things must be kept in mind. Then term of copyright I have already mentioned. Generally it is lifetime of the author plus 60 years. Because of Rabindranath Tagore's Geetanjali and the Bengali lobbies, pressure, it was extended from 50 to 60 years. Now, we have stopped there. In America it is 70 years. Lifetime of the author plus 70 years. It depends. If the author is not identified, it may be only 60 years. I have already mentioned. Till recently, photograph was protected only for 60 years. Lifetime of the photographer was not included. After 2012, an amendment has been made. Today, even copyright in the photograph also, if it is original, protected for lifetime of the photographer who is the author plus 60 years. So anonymous works, sometimes people write with a different name without disclosing their identity. Pseudonymous works, posthumous works, all of them will have only 60 years. This is another important issue. The authors have two important rights, economic rights and moral rights. Economic rights are time specific. Once the copyright term expires, the economic rights also expire. And they include the right to get royalty, right to reproduce, translate, publish. All those things I have already mentioned. Then again, when we talk about resale share right, this is also equally important. We assign copyright to X. Maybe we assign total copyright for 10,000 rupees or let us say 1 lakh rupees. Subsequently the book or the work becomes so famous that he wants to sell it for 10 lakh rupees to someone. Whether the original author has a share in this resale? Answer is yes. If it is more than 10,000 rupees worth, then certainly resale share right is there, that is under 53A. Then there are moral rights. Moral rights are forever. They are independent of copyright. I can copy Shakespeare's rights, I can reproduce, but I can't claim myself to be the author of his play. He has right of authorship, paternity right. Then there is integrity right. This is also equally important. Integrity right is right against undue mutilation, undue distortion. Undue distortion. Because the originality, if it is lost, if it is going to affect the reputation of the original author who must have died 1000 years back, doesn't matter. Anybody can question this important aspect. And neighboring rights are equally important as far as the Swayam and other programs are concerned. Neighboring rights assume greater importance. There are two kinds of neighboring rights which benefit broadcasting organizations and producers of phonograms. And there are two important rights. One is the broadcast reproduction right. I mentioned just now. You create a content, you have copyright in it, you can broadcast it, telecast it any number of times for 25 long years. Nobody can stop you. As simple as that. And after 25 years, anyway, anyone also can do that because there will be no broadcast reproduction rights surviving. Like in the movies which are being telecast, broadcast, almost every second channel will be telecasting the same movie. And in All India Radio, I always say this, whenever there was some obstruction, in our childhood, we used to hear some kind of announcement like this, Antarayaniki Chintistunnam, Ippudu Nilaya Vidvansula Vadya Kacheri. So somebody used to start tabla or something like that until the power was restored and the program was resumed. Today it's not required. Why? Because there is so much digital content. If there is a rain which is disrupting the cricket match, live telecast of the cricket match, we will see the highlights of yesterday's match. Right? So that is nothing but exercising the broadcast reproduction right, but it must be only within 25 years of time from the first broadcast. This is another important point. Performers also. Don't think that Shobha Naidu is a performer or Amitabh Bachchan is a performer. All of you are performers. If you are before the camera, a teacher is a performer. Anyone who gives a live performance, including a teacher, including somebody who delivers a public lecture, also is a performer. Without their permission, nothing can be recorded. That's the reason why you have a sophisticated, the studio, and their permission is necessary. Without their permission, nothing can be telecast, nothing can be broadcast. So performers' rights are also equally important for the organizations like the CEC. Then broadcast reproduction right I have mentioned just now. So right to rebroadcast the broadcast. Then right to make a recording of the same. Then right to publish such sound or visual recording. Recently I received a request from one professor from Pondicherry University. Long time back we offered a course on human rights and humanitarian law. I don't know why there was phenomenal enrollment, more than 10,000 students enrolled. All of them didn't take the exam. That is the real problem. Enrollment is okay, but exam percentage was hardly in few hundreds. And as per your CEC guidelines, there can be a repeat, of the program. He says, I have translated all these lessons into Tamil with permission from, the CEC. Now we would like to publish them as a book consisting of all the lessons. There are 3 or 4 resource persons. He asked me, then I said, you better ask Mrs. Supriya, she must be knowing better. Then she directed them to talk to Dr. Asmita Bakshi, who is known to many of you. She sent a letter. You look at the terms of use and all. The point I am trying to make out is that the publication of even the audiovisual works also is part of the neighboring rights. Performances I have already mentioned, I need not go further into that. Infringement of copyright, this is the problem. Because there is every possibility of someone saying that my copyright is violated. What exactly is infringement? Infringement is defined in about 7 clauses under the copyright law. section 51, like doing something against the terms of the license, maybe substantial copying, maybe undue paraphrasing, maybe not giving attribution to the stakeholders, then using a particular premises only for the purpose of infringement. Infringement is different from plagiarism, please. Plagiarism may not be a statutory wrong in all the cases, but infringement is not only a civil wrong but also criminal wrong. There can be, in fact, punishment, criminal punishment also. Computer program, for example, if you are using a computer program without permission, every person is likely to be behind the bars at least for 7 days. All of us will be behind the bars if the stakeholders insist on that, honestly speaking, whether it is the operating system or whatever it is. So there are number of remedies for that. Then piracy is different. I need not mention much about piracy, but we are supposed to be concerned about the infringement of copyright, which is quite common. And we must avoid that. Every time the exception will not come to our rescue. We always say fair use, fair dealing. Yes, there is a copyright, but we are making use of the copyrighted material for educational purposes, for research purposes, for private use, for reporting of current events. Every time it may not be an exception. So doctrine of fair use has its own limitations, but for our understanding, fair use includes making use of the copyrighted material for research or private study or criticism, review, reporting of the current events, then judicial proceedings, so on and so forth. At the same time, recently in 2012, for the benefit of disabled persons, a new exception has been added. You can see section 52(1)(zb). So, access to copyrighted works by persons with disabilities, subject to conditions. Conditions apply, but this is a good exemption in favor of the disabled persons. Then these are some of the important amendments. The changes made by the 2012 amendment. We have the concept of digital rights management, which is refortified. Then copyright's meaning also is extended now. Copyright doesn't mean only the right to reproduce, right to translate and communicate. That continues. But we have one more, the right to store works in any medium by electronic or other means. This is important. If we have copyright, we can make use of this. Then future technologies, whatever is the form in which it is assigned, that will hold good. Future technologies require future assignments, future agreements. This is another important aspect. Then of course cinemas, because you see there is one Telugu person who worked behind this amendment, Dr. G.S. Raghavendra, who is a product of our library science department. Recently he retired as the Joint Secretary of Ministry of Law, Justice and Company Affairs, if I am not mistaken. He was advocating an amendment at the insistence of people like Javed Akhtar. And point is, in cinematograph works, if any lyric is written, any script is written, any musical work is composed, it must be played as part of the cinema. There is no issue. But if separately the rights are sold, musical works are sold, right, or overseas rights, only in respect of the lyrics, only in respect of the musical works, the original contributors were not given a single bite. Now, in fact, there is a restriction on assignment of copyright. It may not be relevant for our purpose, but incidentally, if we come across any musical work being offered as part of the programs, MOOCs, then we have to remember this. What can be assigned and what cannot be assigned. So, term of copyright in photographs, I mentioned that now it is lifetime of the photographer plus 60 years. Then disabilities provision I have already mentioned. Statutory licenses, of course it is mostly in case of sound recordings. Sound recordings, if anybody, for example, you see Hum Aapke Ek Hum, cinema was there, you remember? Music was very popular and it was HMV which owned the musical works copyright. Then some lesser known person issued a notice and he wanted to produce a few, maybe 1 lakh copies, maybe 50,000 copies. There was a provision for version recordings. statutory license was supposed to be given. Today, one must wait for 5 long years after the release of the original work. Then only one can apply for the statutory license. This is also another important aspect. Broad and exceptions I have already mentioned. For benefit of academia, again this is very important for us. I'll close within 2 minutes. For the benefit of academia, previously we used to say that copyrighted materials can be used for educational purposes. But today we are using the word instructional use. Instructional use is a broader expression. Not only for teaching purpose, educational purpose is only classroom ambience. This instructional use helps organizations like UGC, CEC and many more. So this is another important aspect. Monkey selfie, I will not go into that. Today we are in the age of monkeys taking selfies. This is the monkey which took a selfie and it was published in National Geographic, and the copyright was claimed by the person who made the camera available. Then the organization working for the animals welfare, they filed a case saying that royalty should go to the animals welfare trust, not to the author. But ultimately it was held that only human beings are entitled to copyright protection, but not the in fact monkeys or the artificial intelligence also. Chatbot can claim copyright. The other day I was experimenting with OpenAI before the new version came up. I asked them to, I wanted a poem to be written on Osmania University. It has composed a wonderful poem. Idli Sambar, it composed a poem. You ask and it will do it. Then who is the owner of copyright? Is it me who is giving the instruction? Right? Or is it the GPT chatbot? Can it be considered as a legal person? So far, no. In future, we don't know. But these issues also will come up. I am very sure that even CEC and other organizations will be making full use of AI in the coming years. Then these issues have to be addressed. As of now, they don't have any copyright. So sports broadcasting also. For example, you must have come across a strange experience sometimes. In Doordarshan, the telecast used to come, or even now it comes late of a live cricket match as compared to the private telecast, private channel. Doordarshan, if you have access only to Doordarshan, DD Sports or DD News, whatever, you will get access maybe few minutes late. And whereas 10 Sports, Star Sports, straight away live you can watch. Why? Again, because of this particular aspect. We have Prasar Bharati Corporation, we have a particular law now, and we have to protect the rights of the private broadcasters, but we also have access if they are of national importance. So this is another one, but if you are into live telecast or broadcast of any sports event, then this issue comes. And I think I mentioned about this Rameshwari photocopy works case. Course packs can be prepared. I think legally it is a wrong judgment, honestly speaking. I take a book published by Oxford University, I take one chapter. I take one more book published by Taylor and Francis, I will take another chapter. And then Cambridge University, then Sage, then I put all of them together. Then I make photocopies and make them available at a lesser price. Now all those publishers are trying horse. This is the real problem. But nonetheless, in the larger public interest, especially in providing access to quality material, probably this exception has been upheld by Delhi High Court. People criticized Justice Rajiv End Law. His name is Justice Rajiv End Law. People said he ended the law of copyright. End Law has ended the law, but that's not correct. But a day comes when this judgment will be overruled. I am talking about course packs. So need of the hour is only to demystify the concept of intellectual property rights. I think we have to take a fresh look at all our assignment agreements, all our terms of use, the policies, and keeping in mind the need to provide greater coverage and greater access to the beneficiaries of Swayam programs, probably, understanding of intellectual property regimes and the changes made therein is quite essential. So with these few words, I thank EMRC, Professor Runali Madam and other senior professors, producers and officials for giving me this wonderful opportunity. I thank you all for the patient hearing. I apologize that the presentation started, Dr. Achula also came. It started late, in fact almost half an hour late, and I'm sure that she will make up. Thank you so much.